Hi, ladies and gentlemen. We are back with the SAP IB Business Talks. Today, I have two guests. I have with me Simone Frattasi from Maersk Möller, and he is head of global IP there. So I have an industry representative. We want to talk today about patent portfolio management. And for the ones who follow me a little bit on LinkedIn, and maybe you saw last week, we had quite a discussion on that topic. Thank you for all of you who joined the discussion on Friday. I hope you are today with us. This is a LinkedIn live show. That means that when you write comments, questions here in the chat, so then I can pick that up in the studio and talk together with Simone about that. And we have with us an accredited guest, Aral Barkin Arak. Aral is ambassador partner of the IP Business Academy, and he will help us with the discussion in the chat. So, hello, Simone. Thank you very much for joining us today. Simone, my first question to you is a question which I ask every guest, because typically no kid wakes up in the morning and says, I want to become an IP expert. Okay. So Simone, what is your story? How did you get into this strange field of intellectual property and intangible assets?
Hello, Alex, and hello to everybody out there. So thanks for the invitation first. Well, maybe should I surprise you? Maybe I'm the first one that woke up thinking I should be an IP lawyer. No, I don't think so. So, well, my background is in telecommunication engineering. And when I finished my PhD at Aalborg University in Denmark, then I coincidentally decided to get a job as a trainee patent attorney in one of the IP firms in Denmark. Having worked there, got my training, then moved to another IP firm. So obviously it was coincidental. Before I got my PhD, and maybe the very first encounter was in submitting some invention disclosures at the University of Aalborg, where I got my PhD. But I would say, yeah, it was a coincidence, obviously. And I started as a consultant, and then I moved in-house first in Sony Mobile, where I was the head of the patent section in Sweden, and then now head of global IP for Maersk.
Got you. So you have a decade of experience, and I'm very happy that you share also your experience on the DPLEX, that digital IP lexicon, with which we started again some months ago. And on that, you have a full page on patent portfolio management. And also for the ones who are interested in that, we see here also your upcoming live seminar at Forum. And so this will be a distance seminar in which you talk about strategy and patent portfolio management. Here also an audio overview is created from your book on this page, and some background information from the IP Business Academy is also available here. And when you have some questions, the audience, and want to get in contact before the Forum seminar, so then you can contact here Simone directly. When you want to know more about the book, we have also a review here, which is available on the blog of the IP Business Academy. So everything is available. And some words to Aral. I'm very happy that he is today with us. Aral has also huge experience, more than 15 years in technology transfer. And he works also in the high-tech and R&D sectors, and pretty much tries to bridge the worlds between academia and industry. So that are our guests today. And now I would like to come, Simone, to my first question to you, because we touch a lot of topics last week in this chat, and also in my lectures when I'm teaching with the European Patent Office in our master program, diploma program. We talk a lot about portfolio management, obviously. And one question which arises very often is, how can you develop strategic approaches to optimize a patent portfolio, whatever optimization means? I mean, that is a good question, in which direction then you want to go. But what is your perspective on that?
So generally speaking, I think we need to look at what IP value drivers we have connected to the patent portfolio, or the IP portfolio in general. Now, if we talk specifically about the patent portfolio, obviously, I mean, we can categorize the value drivers between, let's say, 4 to 5, just to give some examples. So the one is obviously in order to create or to emphasize the competitive advantage for the company. The second one could be to create freedom, largely speaking, freedom to operate, but also freedom of supplier selection. So there are, for example, many service companies which are more interested in the freedom of supplier selection, because many of the products or services are in fact developed mainly in collaboration or mainly by the suppliers or vendors. Then there is obviously the part about leverage. So leverage, using the portfolio in the leverage of the collaboration, so in the agreements as well. And then the monetization, which obviously, if you are specifically within a PI licensing businesses, it's quite a revenue stream there. But I would say also additionally, maybe we need to look into a little bit more modern ways to see IP and what models have been developed lately. So going from the more closed IP model of trying to keep a competitive advantage towards more an open IP model, which maybe is more suitable when we talk about sustainability. So, for example, in the recent past, we together with Siemens Energy, we launched an ESG patent pool. So there, obviously, if you look at the categories that I mentioned before, that is not really to keep a competitive advantage per se, or monetize, because the monetization in flow is just symbolic, but it's maybe also it's for the adopting technologies faster, to make development of technologies faster as well, but also getting brand promotion, to see the company as a leader within a certain space, for example, ESG. So I would say these are some examples of main categories where your patent portfolios, parts of your patent portfolios need to tap into.
So I like your picture metaphor of what IP in general is, because it reminds me to a book which I really admire from Marshall Phelps and Derek Klein, about it. The name is, or the title is, Burning the Ships. And they explain, especially Marshall came from IBM, where he developed the idea of making the stick licensing. So at the end, a kind of blackmailing to get the money, so to speak. And then he came to Microsoft, and there he tried to develop a completely new understanding of IP patents in specific, and then he influenced the whole tech industry, what patents are and what they can do. And so to me, that sounds very familiar when you say that we have to understand the role of IP. We have to understand the role within a certain business context. And this is simply not God-given. So we have to understand that in this context, and then we can optimize, whatever optimize means. Did I get it right? What your position is here?
Yeah, for sure. I mean, for example, in my previous company, there was a specific IP or patent strategy which related more to the fact of leveraging the patent portfolio in negotiation, so especially cross-licensing, right? For example, if you are in the mobile communications business, so that is one of the strategies that you would apply. I mean, I would not normally say that there is just one of these value drivers, but it could be that different parts of the portfolio are used in a different way. Now, in my current company, where IP maybe is not the core, maybe it's especially patents, are not necessarily the core of the business, obviously you need to look at the patent portfolio, how it is being utilized. So try to maximize the utilization of the portfolio. I don't want to have a dormant patent portfolio, which is just, incurs costs. So I want to utilize it. And for example, one of the ways of utilizing a portfolio that relates to decarbonization technologies has been that of opening up for a patent pool. And for example, with respect to safety features, we have seen IKEA pledging certain patents with respect to certain safety features. So it gives, obviously, this all gives different advantages and benefits, which could also be a brand promotion or increasing the brand reputation per se. So it's not just about increasing your competitive advantage or giving you freedom, but there are also other aspects to consider.
Yeah, absolutely. And I'm loving, for example, this from Klaus Jennewein, this wonderful study which he published with a colleague, Geribatse, about aspirin and how the exclusivity which came from patents. I mean, it's a molecule at the end, yeah, and it's a very, so to speak, simple or isolated invention. And here you can see the effect. You come from technology-based exclusivity, and then you switch to brand equity, and that makes absolutely sense. Also to think in other technologies in that, with that kind of thinking, so that brand management and patent portfolio management has to come together and has to create jointly effects in the market, right?
Yeah, but also an additional comment, especially since I've attended your IB Business Administration diploma course, I think there is quite a lot of emphasis on the fact that it's not patenting for patenting, each and every technical solution, each and every invention, but it's really about what are the customer benefits, right? And how can you capitalize on those customer benefits? And that is there where you tap into, for example, patenting. So it's not just necessarily everything, but it's especially what gives this premium benefits to the customers.
Absolutely. I have a wonderful question here. Maybe it's a bit detailed, but I know Maria very well. She makes a PhD project with me, and she is an alumnus of my master program, and so I know very well where this question comes from, and I like it because the idea is, okay, so we have quality and quantity, and we have value, by the way, and that are completely different things, different metrics. And the idea is that we balance that, right? Quantity, quality, and maybe also value. The question is, which kind of metrics can we use here, or is it really a question of metrics, or could it be managed in a different way when we try to focus on the one or the other direction?
Maybe just a specific example, and then we can generalize a little bit. In my previous company, we were to get into a patent pool, Avanzi, right? And in that specific patent pool, you have a specific system of points depending on the patents and whether the patents read on certain standards, 3GPP standards, right? That obviously quality there, it's connected to the value in the sense of we need those points to get into the patent pool. So in that respect, obviously these patents, they need to read on the standard. So that means that throughout the whole prosecution, it's very difficult to start with, but obviously the delegates know what discussions have been taken during the different technical committees meetings. But throughout the whole prosecutions, obviously the claims, they need to be aligned to what will be a frozen standard, right? So in that respect, you really have a target in mind. You are sure this will create value. So I think in that respect, quality and value are pretty well connected. Otherwise, you have seen in the recent past that there has been launched this industry patent quality charter by Siemens and other companies as well, right? And there is a little bit of a discussion between quality and quantity, especially before the European Patent Office. And I think us and many other companies, they have a little bit of a difficulties in this respect, because what is the business driver, right? Because volume can create a business benefit, can create a certain advantage, right? We said, for example, what about utility models? Utility models, in many cases, they are not examined, for example, but they are still bothering a competitor because the competitor needs to review these utility models, maybe open an examination around them. So in a certain sense, they will spend time and money, right? So everything can be used, and volume can be also used to create a certain business advantage. So I understand that quality obviously means value, means enforcement, and so on. But I wouldn't disregard volume, because volume can also be used, especially in negotiations, especially with respect to, for example, cross-licensing negotiations. So
Got you.
I wouldn't disconnect them completely, I would say. But if you say quality per se with respect to a patent application, obviously it's the enforceability, it is the fact that there is a target that is aligned with the claims, and that falls obviously within one of the value drivers that we mentioned before. But I wouldn't just say, okay, let's disregard totally volume, let's just go after, for example, the invention that could be really a breakthrough, and that's it. Um, I think many companies have difficulties to accept the fact that, let's say, volume should be disregarded in this term.
Yeah, yeah. So basically, there are two different metrics, and we cannot exchange them arbitrary. So we have to think about both independent, and obviously there are reasons for having more patents than less, and there are reasons to look very specific on a kind of quality, and this kind of quality needs an understanding for the value drivers. I think that makes a lot of sense, at least for me.
Maybe
Okay.
to add on, right? So I mean, obviously the metrics that I show in the book are related to, if there are specific targets. Targets can be technical standard, can be potential infringers. It can also be the fact that us as a company, we use these patents, right? So obviously, when you have an infringer, when you have technical standard, you have more of an active perception of the quality. While if it's about more, we are using it ourselves, I think it's difficult to, if there is no infringement, whether to know if a competitor maybe have designed around, they found alternative solutions, maybe not as optimized solutions. I think it's more of a passive. It's more difficult to quantize it, but you still have it there, right? So in the book, there are this type of metrics, whether you use it, whether it's a competitor using it, or if none of the two, if still the invention which relate to this patents obviously is still, if it's obsolete or still valid as a
relevant,
and then
let's say.
then this all falls into the specific value drivers. So how do you use these patents? And in a certain respect, I'm not saying that we should just file drafting patents and filing patents just for the sake of it, but that the volume can also obviously have its own space in respect to making competitors spend the time and the resources. It has some benefits obviously in certain circumstances, right?
So Ara comes with a timing question or timeline questions. So we have short-term activities, perspectives, medium-term and long-term perspectives, or different kind. I would not say that there is something like a short-term strategy. That doesn't make any sense, but I think I understand what he means. So we have different time frames in which we can act. So do you think that it makes sense to differentiate that? One thing which comes into my mind is that, for example, Maria asked that question on Friday. She said there is something like a post-grant management, for example. So this is also a time frame issue. So does that has an effect, or is that something which is not really relevant? What would you say?
Well, I mean, you always try to optimize your prosecution depending on the needs that you have, right? If you want to accelerate prosecution because you found that, for example, there are certain infringers, then obviously that's one of the way. Then it's maybe that is shorter term, but always connected to the strategy of the company, right? There could be another way, obviously, is to delay the prosecution because you don't see there are specific targets for that specific patent, for example. And then for what regards the post-grant, maybe, for example, in US, you can reissue the patent in case maybe the claims could be directed to a target, but they don't really overlap fully with that specific target. Then maybe you could try to reissue the patent, even though it's obviously an expensive procedure, but to try to really to align the claims of the reissued patent to the target. So I think in general, you need to follow the prosecution needs to follow the business needs, right? So, and the business needs may change. It could be that you have filed a patent application that relates to something that you yourself develop and use, but that maybe is suddenly not obsolete, but it can be that you get another solution that works better. Then at that point, obviously, you need to look into why should I continue the prosecution for this patent, or why should I maintain this patent? Obviously, you can look for licensing in specific countries in which you don't operate, for example. So you can think a little bit creatively, unless you want to prune the patent as well. So in the book, there is a specific chapter also related to the pruning. So, and there is a sort of a semi-automatic tool that I developed a couple of years back, especially for very large portfolios. I mean, when you get over the 10,000s and over that, then it's obviously really difficult to have many reviews. And in many cases, you do, for example, a notice of allowance review, or you do a post-grant review. But obviously, the post-grant review, at that point, it's very late, right? So you have just, for example, you can reissue the patent, but it's very expensive, so it's too late. So in the book, there is a bit of a balance in between how often to do this review, when you can do these reviews strategically, and there is also something about pruning in a more automatic way, in a sense of just pulling up the part of the patent portfolio that should be, in fact, being reviewed. And it's always connected to the renewals, because, renewals coming up in 2 months, maybe you just review that part of the portfolio, but then this tool provides you just this part of the patent should really be reviewed. The other ones, because of certain metrics, you continue to review them, to renew them without making, let's say, a review, a specific review.
Yeah, got you. So this is also a question of frequency and also of effort, because when the portfolios become too big, you cannot do everything at the same time, obviously. Okay, right. Got you. So a question which is really for many in the audience, I guess, a burning platform, is the question of financial planning. So obviously, the whole show costs money. And at the end of the day, we have to explain that to the people who give us the money. So the question is, how can you conduct a financial planning, or in more broader terms, a resource allocation when it comes to patent portfolio management? What is your recommendation on that, or also your experience on that?
Right. So, I mean, generally speaking, there are companies in which let's say the expenses around the patent portfolio are centralized. So it's the IP department or the patent department that has that budget, as the cost center. So in that respect, obviously, it could be that all the legal expenses, maybe besides the inventor rewards, are within the scope of the patent department. In that respect, obviously, you have a lot more freedom to decide how to allocate the different resources. For example, in terms of possible litigations or possible oppositions that you want to budget for. Obviously, there are IP management systems and other tools that can make a forecasting model based on, for example, new filings, current prosecution volumes, and different filing strategies, and so on. Another side of the coin is maybe where you have the different business units, which all different legal entities, which have the budget and authority also with respect to their own patent portfolio. So in that respect, it may be difficult to say we are one company, right? Because the different business units or legal entities may have their own agenda a little bit. And also it could be delayed, the prosecution, sometimes because you always need to interact with all these different business units, maybe having, different awareness around IP in general and patents, how to use them as well. And so that's a little bit more tricky. Then obviously that's all about the patent department creating that awareness, creating that need, and then knowledge around what are the value drivers around this patent portfolio. So why do we need a patent portfolio? What are we using that for? And for the different business units can be really different. For example, in Maersk, we have certain business units for which the patent portfolio is used more for the freedom to select a supplier, freedom of supplier selection. For other business units, it's really more about creating a competitive advantage and other value drivers as well. So
it's
obviously,
like
generally,
having different companies to a certain extent, right?
Yes, exactly. So obviously, it's more fragmented. It's all about creating, as a patent department, the need and the understanding on why the patent portfolio is valuable and how the different legal entities should use it, but also somewhat try to see it as a one company patent portfolio, right? So also see the benefit of we need to have a sizable portfolio for risk mitigation purposes. Because let's say in our case, for example, we open up with many different software solutions. And so there is a new competitive landscape to consider. It's not the same as 5 to 10 years back. So we could encounter more risks in that sense. So a sizable portfolio as a whole company would be useful.
Yeah, got you. I mean, that refers to understanding the value drivers. And so what you say is, so my understanding is that you have different levels of value drivers. So you have value drivers which are relevant for the different business units separated, but then there are also value drivers which comes on a higher level, which affects the whole company. I mean, this is exactly what we discuss in strategy management, that there is something like a corporate strategy, and then we have a business strategy, and then we have within the business strategy, we have different functional strategies. So that reminds me to that, right?
Yes, for sure. And of course, I mean, there could be, I mean, you would follow the development of your costs throughout the year, also with respect to the budget that you have allocated. And there are, especially in the book, there are listed many different countermeasures that you can use. So obviously pruning being one of them, but there could be many other countermeasures depending on at which stage, which type of issue with respect to the budget you have. So it could be obviously, for example, if you're using a secondment, if to reduce secondment, or for example, if you have a specific threshold for how many new filings you have, to decrease that threshold, or maybe increase the number of pruning, the volume of pruning that you do, right? Because as soon as you cut over some cost here from the pruning side, then maybe you have more allocation from for the new invention. Also, it really depends on the company situation, because if the company is, for example, in financial trouble, then obviously, and especially when you have the business units or legal entities that have the authority and are responsible for the cost of the patent portfolio, you will need to adapt. Adapt means maybe you need to insource more. Maybe you need to create a sort of a quasi-zero structure for patent cost, just to say, filing provisional patent applications without paying the official fees, because then obviously the cost is just about drafting. And at that point, you can outsource offshore the drafting, or you do it in-house. Then you have the 1 year time, and then you can take decisions at that time if you see that the financial situation of the company has changed. So you always take a decision. You create a structure depending also on the company situation, right?
obviously. No, I got you. I have different, very fascinating questions right now in the chat, and maybe we will be not able to ask every and answer all questions, but Simone will later on stay tuned on the chat and give you answers to your questions. And we have the forum seminar also where you can talk a whole day with Simone. So one question is puzzles me, because I had the same question mark in my face. So Mayank Singh says, what exactly is the freedom to supplier select? This is something which is also new for me, and
Okay, interesting.
tell me a little bit about that.
So let's consider MESC for a minute. We are a company that maybe doesn't itself necessarily develop products or services, but uses many different suppliers, right? In different technical areas. So in that respect, there are a lot of discussions around collaboration agreements, and in collaboration agreements, obviously, you need to talk about IP ownership, and in many cases, you can face the business saying to you, but why shouldn't the supplier own the IP? And obviously, the answer would be because then you would not be able to freely select the supplier. If you want to change the supplier, then you would have a problem with that, right? So in that respect, owning the IP, now, very simply speaking, owning the IP obviously gives you the control and gives you the freedom to select the supplier in case you don't want to work with that specific supplier anymore. Now, this can be covered also in the agreement itself, in the collaboration agreement, but it's much easier to state that you own the IP and you will file intellectual property rights with respect to that, for example, the different inventions, the different patents. I think it's a much easier way than filling in a collaboration agreement with all these different clauses, because as soon as you forget the made use, for example, then maybe you're stuck with a specific supplier. So freedom of supplier selections means that you have the freedom, even though you work now with this supplier, to develop something together or according to your specifications, that then you can freely move to another supplier.
Got you. Thank you very much. Yeah. So, so you want to avoid the so-called vendor lock-in, right?
Yes.
So it's in IT that has really a name, and also at the moment we talk a lot about that when we come to certain models on in large language models, and on which foundation model you work with, and you want to avoid a vendor lock-in, because today one model works very well for you, and 3 weeks later another one is competing or even better, so you want to be able to switch, and you don't want to be fixed for the rest of your life to a certain software or a certain language model or whatever. Yeah, lock-in effects are absolutely critical. So Peter Anderson has a very good question, because we're talking about that in the fifth module of my master program a lot with the students. I mean, the students are patent expert or IP experts with at least 3 years of experience, and we talk with them always about insourcing, outsourcing, and there's no wrong and right. So there are different situations, different reasonings. What should be done in-house? What should be done by external competencies, but also especially resources. So it doesn't make sense in any case, in all cases, to insource everything. On the other hand, typically outsourcing everything is also not a good idea. So it's always a balancing act. So can you give us your experience with that discussion, and a certain kind of recommendation how to think about that?
Yeah, there is actually a whole section in the book related to insourcing, outsourcing, what type of criteria to use in respect to what parts to outsource and insource. I think it really depends on the mission of your IP department or patent department. Just to say, in my company at the moment, because of the level of awareness at that time where I established the patent department, I think what is most important is value and visibility. So create an impact, create a value, but also give visibility. So whatever we do in the IP department in general, especially in the patent department, needs to create an impact for the business, but also it has to give us a certain visibility, because otherwise we'll never be so impactful. So just very simply speaking, to say, if to draft in-house an additional patent application doesn't bring to management any value per se, any more visibility to the patent department, so probably you should do things in a different way. So obviously there are certain things, just to say, searches, which I think you could probably offshore. I mean, it really all depends on the budget, on the resources that you have in-house. That all depends also on where you can create value, right, for your company. Let's say searches could be, for example, outsourced or offshore, but the analysis of the results, for example, especially in case of freedom to operate analysis or landscaping, it should come from you, because you are the one close to the business, right? You are the one close to the different business units, like in our case in Maersk now, where you know what value you can create for each and these individual business units. What are their needs, right? Unfortunately, the external firms very seldomly have this interaction with the business, right? And know the business so well. But again, for example, it could be, I was asked, because I've had a look at many, AI drafting tools at the moment, or prosecution tools based on AI, and say, but would you use this tool or not? Then you can also say that many different companies, they have many different tiers, even starting from, before the filing of a patent, when an invention is received. And again, it could be that it could be a technological breakthrough where you would maybe assign resources in-house, while for something that is minor, according to the business, you could say, well, this one maybe can be outsourced or offshore. It can also be done depending on the priorities and the values, right?
Let me summarize the answer.
Please do that.
I think what you say is exactly what Ruud Peters explained us 20 years ago, and which always take this example from Ruud and his Phillips approach. There's a wonderful paper out there, in IIM, the Phillips formula. And I give that every year. I give that in the first module, in the strategy module, to the students. That I don't recommend to do it like Ruud, but the reasoning is smart. And he said at the end exactly what you say. He said, try to understand what brings the value and what is at the end administration or can be done anywhere else, because you have not really an value lever in it. There is no leverage. You just have work with it, and then the reasoning comes, and what you say is what is close to the business and where you really need this deep understanding. These value driver analysis, this understanding of the business, there the in-house team should do that, and in the other cases you have very good reasons not for doing it in-house. I mean, that is my summary of what I understood what you said, right?
Yeah, I'm sure. I mean, for example, it could be that you need to create more awareness throughout the business about IP in general and patents, right? So in that respect, you need to prioritize the different tasks that you have. So for example, in our IP department, we are basically taking care of any IP issues within the company, including IP clauses in contracts, and obviously creating awareness for the business up to M&As and involvement in those. So it's not just the portfolio management, and also the brand protection. So in that respect, you need to understand where to put the priorities and to allocate resources accordingly. So if something doesn't bring that visibility, doesn't bring that substantial value, where you can sit in front of management, and management can understand what you're bringing to the table, then I think you need to revise how you allocate your resources and what priorities do you have. But I mean, the priorities are always coming from the business. The company has certain priorities, and you need to enable those priorities thanks to your patent portfolio, for example, and in general to your IP portfolio and your actions as an IP department.
Got you.
Just maybe one example, Alex. So maybe not necessarily strictly on patents, but related to brand protection. If I go to management and mention we took down 50,000 web domains, that doesn't say anything to management. Management wants to know, for example, in terms of lost sales, how many millions we have saved, right? So I think you need to basically convert takedowns into something that is digestible for the management. And the same is for the patent portfolio.
Can't agree more. And this is a wonderful answer to the winning question from Friday. Because Stephen Carter asked the question, what information about the patent portfolio or the portfolio in general should be communicated to the board? And I mean, that is, for me, this is exactly the answer. It has to be tangible for them. And at the end, it has to do something with business. And this has to be explained. Is that your experience too?
Yeah, I mean, if we have a very long list of metrics that we use to, let's say, to follow up any actions that we have, not just related to the patent portfolio. It could be something related to operational efficiency, something related to growth. So we always try to convert this specific metric into something that is easy to communicate to management, right? Or to the different stakeholders. In respect to the patent portfolio, the very first thing that we did at that time is to visualize the portfolio, not just against obviously the different legal entities, but also with respect to the different technical areas, and also with respect to how this portfolio is used. Is it used for, for the competitive advantage bit, or is it used for the freedom bit? Is it used for the monetization part? How is this used? And for example, this part of the portfolio that is not being used yet in terms of doesn't really have targets yet. So how do we want to activate it? So obviously the visualization of the patent portfolio, and you find it in the book, is one of the very first things that is something that is digestible for management to understand, okay, what is there and how it's used.
Okay, thank you very much. So we're running out of time, I'm afraid, and I don't want to close this session here, this episode of the Sapir IP Business Talks, without recommending everybody your seminar, the forum. We have also on the blog, we have also there the explanation of the seminar, and which you organizing, and where you be the expert for all the questions. It is overwhelming. We have wonderful, very detailed question. It would be great, Simone, when you take the time and answer to that questions in the chat during today, maybe. So I'm not feeling well prepared to give answers to that questions. And I hear again and again, and I can only confirm that it is written in the book. And this is really was my first impression when I read your book. I said, okay, I would like to write a review about that, because it's really a detailed one. Obviously, it comes from practice, and it's not any, this kind of theoretical mind creations. And there is something which comes from the experience out of practice, and this is exactly what we need in that field. So thank you very much for that. Thank you for joining us today. To all the others, Simone will be available in the chat, and feel free to ask your questions. Thank you to all of them who discussed with me on Friday in preparation of this wonderful live show. So we will be back in 2 weeks with Sebastian Goebel. And till then, I wish you a great time. Thank you very much, Simone, for joining us.
Take care. Bye-bye.
Thank you. Bye-bye. Bye-bye to all of you.